Here's an important update on a big Second Amendment case that we've been tracking in the state of Florida. You see, in most states, 18-year-olds are considered adults for most purposes. We know this, right? Once you're 18, you can vote, you can sign contracts, you can get married, you can join the military, or even be drafted. But you know what? In many instances, in more and more states, including Florida, 18 to 20-year-olds cannot buy firearms. When we come back, I'm going to give you some news about a federal court law challenging Florida's age-based gun ban, which I think is unconstitutional. And this case, of course, is an important test case for all of our gun rights and the meaning of the Second Amendment's right to keep and bear arms. Hey folks, I'm Mark, and welcome to the Four Boxes Diner. A few months ago, I told you about a Florida law that prohibits 18 to 20-year-olds from buying firearms. I also told you about a legal challenge to that law that's been making its way through the federal courts. Well, big news, the 11th Circuit Court of Appeals has now scheduled oral arguments for this case. They're going to be held on March 24th. That's March 24th, 2022. Remember that date, circled in your calendar. And why is that? It's because this case could ultimately affect your gun rights, even if you don't live in the state of Florida. You see, several states have added minimum age gun laws, just like the one we're talking about in Florida, and the anti-gun lobby is pushing for more and more. And why are these laws unconstitutional, in my opinion, right? Why? Well, you see, as I explained in prior videos, if you first look at the text of the Second Amendment, it says the right of the people to keep and bear arms. That's of the people. Well, not some of the people, but all of the people, okay? And it's not like the framers of the Constitution later thought, whoops, we forgot to mention that people only includes those who are over the age of 21. Well, here's the proof. Historical proof, which is what the Supreme Court tells us we must look at. The text of the Second Amendment and the founding history around the meaning of the Second Amendment when it was written and adopted, okay? You see, the Constitution itself spells out minimum ages when it believes they're appropriate. For example, like becoming the president or a senator. There are age requirements for those. You can't be the president unless you're a certain age. So if our founding fathers wanted to add an age requirement for exercising our Second Amendment rights, they certainly knew how to do so in other parts of the Constitution. Or how about this? Let's take a look at a law that Congress passed only months after the states had ratified the Second Amendment in the year 1791. And that is the law, specifically two laws, the Militia Acts of 1792. These acts required all men between the ages of 18 and 44 to own guns and report for militia service as required. That's right, the federal law enacted by the first Congress, the same Congress, mind you, that wrote and adopted and recommended the Second Amendment itself. This first Congress, the same people, they said that the Militia Act of 1792 required 18-year-olds to be able to, and be required to, in fact, buy firearms as part of their militia service to the country and to their states. It actually required them to do this. So it seems to me, under the text and history of the Second Amendment, this age-based gun ban or gun purchase ban down in Florida should be struck down as unconstitutional. We'll see what the judges do. But it's interesting that the state of Florida right now is defending this age-based gun ban by arguing that the human brain is not fully developed by the time you're 18. Okay, that's fine. So does that mean that 18-year-olds also shouldn't be allowed to determine the future of our country by voting? What other rights should they have to give up other than the right to, under the Second Amendment, right? And I find it also hard to believe that 18 to 20-year-olds are somehow old enough to fight for our country, but they're not old enough to protect themselves and their families from bad guys at home. We got to keep also in mind that a lot of 18 to 20-year-olds, they're at that age where they have to take the shifts that maybe aren't so great. They have to do the third shifts. They have to work overnight. They have to work late because, well, they're just starting out in their careers. So does that mean some nurse who's leaving the hospital at 2 in the morning after her shift, walking through a dark garage, driving her car home through dark streets, and then has to park on the street in front of her apartment building or her home, is not allowed to have a gun because she's somewhere between the ages of 18 or 20? Does this mean that those 18-year-olds who fought to defend and protect our American freedom in various wars over the years shouldn't be allowed to buy guns when they're here in America, specifically in Florida? I guess we'll have to take away all their war medals because they weren't allowed to have a gun. Obviously, that's absurd. If we trust 18 to 20-year-olds with other sorts of rights and responsibilities as adults in Florida, we certainly should allow them to be able to buy a firearm to protect themselves and their families from the same criminal elements that are out there threatening police and other people that are over the age of 20, right? They walk the same streets. They're no different streets. They just happen to be between the ages of 18 and 20, and yet they apparently, under Florida law, cannot buy a firearm. I think that's absurd and unconstitutional. There's another piece of information that I think you should know about. You see, like other gun bans, minimum age requirements simply don't work in terms of public safety. The RAND Corporation, which is a major corporation, does a lot of important social science research. I would not call them part of the vast right-wing conspiracy. They're very, very establishment, been around for a long time, done serious social science and other research. Well, the RAND Corporation did a major study kind of on this question, and they really could not find any convincing evidence that age-related bans decrease mass shootings, violent crime, or unintentional injuries or death. And I'm going to put a link to this study down below in the description of the video so you can check it out, make sure I'm telling the truth. And keep in mind, the RAND Corporation, again, is not the NRA or any group like that. They're about, in my view, about as establishment as you can be, very reputable and have been for literally decades. So why are we even bothering with these unconstitutional gun laws? And one wonders, why is Florida even defending these gun laws in court, given the history and the text of the Second Amendment, in addition to the public policy considerations, which really should not be major considerations when it involves the Second Amendment, but can be something to consider at least for further information and thoughts. So let's wrap up. Circle the date March 24th on your calendar. That's when the 11th Circuit Court of Appeals, a federal court of appeals, will be hearing oral arguments in that important case that we've been talking about here on this channel, testing whether 18 to 20-year-olds can be blocked from buying guns in the state of Florida. Now, I think the court should strike down Florida's silly law on constitutional grounds under the Second Amendment, because I think it's unconstitutional. In my view, age-related bans are contrary to the text of the Second Amendment. They're also contrary to the history of the Second Amendment, including, of course, the Militia Acts of 1792, enacted by the same Congress that wrote the Second Amendment, okay? And again, they don't really work anyway in terms of, protecting public safety. Last summer, by the way, I should mention the Fourth Circuit Court of Appeals, which covers the area of Maryland, actually ruled that federal laws that ban 18 to 20-year-olds from buying handguns are unconstitutional. So that's a good precedent that perhaps the 11th Circuit may be able to rely upon in striking down Florida's gun law under the Second Amendment. I do want to mention the Fourth Circuit Court of Appeals decision ultimately voided that decision, but not because they changed their mind or thought that the law that did not violate the Second Amendment, but it turned out that the woman who challenged the laws, the plaintiff, had actually turned 21 years of age, which made her case moot. She kind of lost standing because, well, she was 21, could get a gun at that point. So again, but when it comes to the Florida case, this is an especially important test case for gun rights, including the meaning of the Second Amendment in the 11th Circuit, including Florida. So I hope, again, you've learned something today about the Second Amendment and your constitutional rights, and I want to thank you again for joining me here at the Four Boxes Diner, where we serve fresh, hot Second Amendment news and analysis. And if you like what you heard, I really appreciate it if you can subscribe and help us spread the word. We're trying to grow the channel and get more people to learn about the Second Amendment and the history of it. And again, we look forward to seeing you next time here at the Four Boxes Diner.
Orders up. Table 2A.